Before the Civil War, most states limited voting to white males. Only 5 New England states allowed black men to vote. New York enfranchised black men who met property requirements that did not apply to their white counterparts. After the Civil War, voting rights for black men were still controversial, and several northern states rejected proposals to lift racial restrictions. The 15th Amendment guaranteed the right of black males to vote, but it was ratified with difficulty. Some opponents thought it went too far. Some leading supporters of women's suffrage denounced it for limiting the franchise to males. The 15th Amendment narrowly forbade racial discrimination, but it rejected earlier visions that would have prohibited property qualifications, literacy tests, and poll taxes. And those gaps would have profound implications. At that time, most African Americans lived in the South. After the ratification of the 15th Amendment in 1870, black men in that region were able to vote, and some won federal, state, and local offices. But black voting rights remained contested. Starting in the early years of Reconstruction, the newly formed Ku Klux Klan and other white supremacists violently attacked black voters and supporters of black political candidates. A notable example was the Colfax Massacre of 1873, where scores of blacks were slaughtered for their support of the Republican candidate in the 1872 Louisiana election. The Colfax Massacre led to a Supreme Court decision in United States versus Cruikshank, 1876, that ruled the federal government could not prosecute individuals for civil rights violations against African Americans. Black voting and representation dramatically declined in the 1890s as a result of violence, outright fraud, and the reestablishment of white supremacy. Complicated voter registration rules and literacy tests allowed white election officials broad discretion to reject black voters. White officials made their motivation clear. An Alabama official described the goal: to establish white supremacy. A Virginian said he wanted to disenfranchise every Negro I could disenfranchise under the Constitution of the United States. These efforts decimated black voting and representation. By the beginning of the 20th century, black voter registration percentages had plummeted to single digits, and blacks disappeared from elective office at all levels in the South. Once whites regained political control in the South, attention turned to excluding the few blacks who were registered from casting ballots in Democratic primary elections. But the Democrats controlled what came to be called the Solid South. Democratic primaries in that region were, for practical purposes, the only elections that mattered. Black voters were largely excluded from participating in Democratic primaries. Challenging those race-based exclusions posed formidable legal questions. But in a series of rulings beginning in 1927, the Supreme Court eventually struck down the so-called white primary. All of these cases came from Texas. The first decision, Nixon versus Herndon, invalidated a Texas law that barred black persons from voting in primary elections. Texas responded to that ruling by taking a series of steps that claimed to leave the decision as to who could participate in primary elections to political parties. This, the state hoped, would make the parties responsible for the exclusion of black voters from primary elections. The Constitution forbids the government from engaging in racial discrimination, but political parties are private organizations that could operate free from constitutional constraints. The Supreme Court reached inconsistent results in the next couple of cases, but in Smith v. Allwright, 1944, the court rejected efforts by the state party to exclude blacks from participating in primary elections. The opinion emphasized that the party was pervasively regulated by the state, which made the party's white-only policy the type of discriminatory governmental action that the 14th and 15th Amendments prohibit. Smith v. Allwright had practical as well as legal significance. That decision emboldened black activists to try to register black voters, and those efforts had some success. Harry Moore and the Progressive Voters League registered thousands of voters in Florida, and Professor Charles Gomillion of Tuskegee Institute registered hundreds of voters in his hometown. Blacks represented a relatively small fraction of the electorate in both places, but they were sometimes able to determine election outcomes when the white vote was closely divided. One indication of the impact of these registration campaigns was the backlash they generated. Harry Moore and his wife were killed when their home was bombed on Christmas night, 1951. And segregationists in the Alabama legislature redrew Tuskegee's borders to remove virtually every black voter from the city limits. Fred Gray took the lead in challenging the Tuskegee gerrymander. He persuaded the Supreme Court to issue a unanimous decision in Gomillion versus Lightfoot in 1960 that returned black voters to the city. Writing for the court, Justice Felix Frankfurter concluded that changing the shape of the city from a square to an uncouth 28-sided figure violated the 15th Amendment by depriving the former black residents of their right to vote based on their race. Recognizing that those residents could still vote in state and federal elections, even if they could no longer vote in municipal elections, a concurring opinion found that the measure violated the 14th Amendment. The different rationales didn't affect the outcome, but the concurring opinion helped pave the way for the one-person, one-vote rulings in the next several years that led to major changes in congressional, state legislative, and local governmental districting. Meanwhile, Southern blacks who lived in smaller cities and rural areas continued to have difficulty registering to vote. By 1957, only 20% of voting-age black people in the South were registered to vote. Attempting to register or assisting other black people to register was dangerous. For example, 2 weeks before the murder of Emmett Till in August 1955, voting rights activist Lamar Smith was shot dead in broad daylight in front of eyewitnesses in Brookhaven, Mississippi. Nobody was ever prosecuted. Congress passed the Civil Rights Act of 1957, the first federal civil rights law adopted in over 70 years. But the move was largely symbolic. Its main substantive provision authorized the Attorney General to file civil lawsuits, to enforce existing legislation, and to obtain injunctions requiring compliance. Violation of an injunction would be punishable as contempt of court. But the act provided for trial by jury in contempt cases, and the likelihood that Southern juries would convict violators rendered this approach an illusion. The ineffectuality of the 1957 Act and the Civil Rights Act of 1960 led the Student Nonviolent Coordinating Committee, SNCC, to send field workers into rural communities in an effort to register black voters. Among those field workers were Robert Paris Moses, John Lewis, and Chuck McDew. Their work led to the Mississippi Summer Project of 1964, the creation of the Mississippi Freedom Democratic Party, and the Voting Rights Campaign in Selma, Alabama in 1965. Fred Gray filed and won Williams versus Wallace, the federal lawsuit that required Alabama authorities to allow the Selma to Montgomery Voting Rights March. He obtained a detailed order from Judge Frank Johnson that defined the route of the march and the state's obligations to protect the marchers. That march grew out of the events of Bloody Sunday on the Edmund Pettus Bridge, which prompted President Lyndon Johnson to propose the Voting Rights Act of 1965.